Yes, we can start.
It's online now, sir. It's we are.
And sir, let us start the program.
Yes, sir. Thank you, sir. Good afternoon, all. Today we have joined for the webinar on recent amendments in Companies Act, CARO, and Schedule 3. On the screen, myself, Aryan KK, Chairman of Thrissur branch of ICA, Chairman of other dignitaries, Chairman of Institute of Company Secretaries of India, CS Sunil Babu, yes, President TMA Thrissur, Dr. VM Xavier, ICA CMA Thrissur Chapter Chairman CMA Jagdish AD, Chairman ICA Palakkad Branch CA Vinoj B. Menon, and Speaker of the Day CS Dr. Yashri Dikshit. Now, let us start today's webinar with a silent prayer. Thank you. Respected Speaker of the Day, CS Dr. Yashri Dikshit, President TMA Thrissur Dr. VM Xavier, Chairman of Institute of Company Secretaries of India, CS Sunil Babu, yes, ICA CMA Thrissur Chapter Chairman CMA Jagdish AD, Chairman Palakkad Branch of CA Vinoj B. Menon, Office Bearers of Thrissur Chapter of ICSI, ICI CMA, TMA, ICI Palakkad Branch, are members of different fraternity attending the seminar. Ladies and gentlemen, a warm good afternoon to all. At the outset, let me thank ICSI Thrissur chapter for arranging this webinar and inviting other chapters organizers to join for the knowledge sharing of the webinar. It is an honor to Thrissur branch receiving this opportunity, also giving the privilege to welcome all the respected speaker, dignitaries, and members of most elite groups attending this webinar. There are a lot of changes happened during this year in today's topic, which will deal with speaker. Today we have an eminent speaker on this subject who accept our invitation for joining with us for sharing her knowledge and views. Let's hear from the speaker. On behalf of the Thrissur branch, TMA, ICI CMA, ICSI, ICI Palakkad, and Thrissur chapter, its office bearers, and all the viewers attending the webinar, let me welcome the speaker, CS Dr. Yashri Dikshit, to this webinar. I do welcome Chairman of Institute of Company Secretaries of India, CS Sunil Babu, ICI CMA Thrissur chapter Chairman, CMA Jagdish AD, President TMA Thrissur, Dr. VM Xavier, Chairman Palakkad Branch of CA Vinoj B. Menon, and Managing Committee members of Thrissur chapter of ICSI, ICA CMA, TMA, ICI Palakkad. I also welcome members of different fraternity attending the webinar. Thank you. Now, let me call upon President of TMA Thrissur, Dr. VM Xavier, for presidential address. Over to you, sir.
Thank you. Chief guest of this day, CS Dr. Yashri Dikshit, the ICAI Thrissur chapter president, CA Ideal, CMA Thrissur chapter president, CMA Jagadish, Palakkad ICI president, CA Vinod Menon, Thrissur chapter of company secretary, CS Sunil Babu, yes, chartered accountants, company secretaries, cost accountants, then management professionals, ladies and gentlemen. Indeed, I am very much happy today and delighted today when I got the opportunity to preside over this meeting. Nowadays in Thrissur, we have a practice that whenever we get learned people from outside Kerala or from inside Kerala or outside India, we do this exercise collectively. Because as CA Irene said, we want to share the knowledge with the similar type of people. And we have a very good relationship with all the professional bodies in Thrissur as well as Palakkad. And CS Sunil Babu sir called me one day and said, From Ahmedabad, they got a reference regarding our chief guest, CA Dr. Yasri Dishit. Somebody from Ahmedabad suggested that she is a very good speaker. And the people in Thrissur wants to get this kind of talk because nowadays we have the lockdowns, we have enough free time, and it is a time to sharpen our knowledge. Without knowledge, we cannot survive in this profession. And Srimati or say Mrs. CS Dr. Yasin Dishit will enlighten us about the latest development in the Companies Act of 2013, as well as what is happening to the recent amendments in Schedule 3 and recent amendments in the company auditors reporting order. And we want to know if we are not attending this kind of seminars or webinars, it is not easy to read and understand everything. So once you get the classes from a well-known speaker like this, that will be really helpful to our profession. And today, I don't want to take much of our valuable time because we are all sitting here to hear CS Dr. Yasri Dishit. So I take this opportunity to once again welcome CS Dr. Yasri Dishit and wish all the best for today's meeting. Thank you very much.
Thank you so much, sir.
Thank you.
Now, let me call upon CMA Jagdish sir to introduce the speaker of the day. Over to you, sir.
Thank you, sir. Today we have an eminent resource person, Dr. C.S. Yashri Dikshit. About when we are going through his her profile, it's lots I have to read. Dr. C.S. Yashri Dikshit is an associate member of Institute of Company Secretaries of India, as all we know. Apart from that, having a qualification in the Master of Commerce and completed her doctorate in analysis of corporate governance practices of selected Indian companies as at GLS University, Ahmedabad. She has certified independent director at Indian Institute of Corporate Affairs. She has worked as a practicing company secretary at Yashri Dikshit and Associates. She has a teaching experience in business and corporate law. She has conducted several executive development and training programs for company secretary students at the Institute of Company Secretaries of India. She has conducted various webinars on intellectual property rights with various institutes at the national and international level. She has taken webinars on annual complaints of private companies, public companies, and LLP of various ICAI chapters. She has a MOC expert faculty member at Gujarat University. She has judged in national level case analysis competition and business plan event of Nirma University. She has conducted a number of research articles in a national and international journals. She is a woman independent and director of guys called Alloys Limited. She has received top 100 Global Woman Inspiration Award from ICANN Foundation, Jaipur, and Woman Managing Director of the Year Award from GISR Foundation, New Delhi. And many more are in the list. So I'm really happy to introduce you, ma'am. I think these words are not enough to introduce you. I hope all have gotten a bit idea about our today's resource person. Thank you, sir.
Thank you, sir. Now let me request speaker of the day to start the session.
Yeah.
Over to you, madam.
Yeah. Thank you so much, sir. Aryan sir, Sunil sir, Jagdish sir, Vinod sir, and Xavier sir for giving this opportunity and deliver the session at all our three institute, ICAI, ICSI, and ICWAI. So should I start my session, sir?
Certainly.
Sure.
Is it visible my screen, sir?
Yes, visible.
Yes.
Once again, a warm welcome to all the members, and I hope you all are well in this pandemic situation. The today's topic is recent amendments in Companies Act 2013, Schedule 3, and CARO 2020. As we all are know, there are the lots of amendments which come day by day, but some of the time what happens, we miss out some of the amendments, we miss out some circulars and some of the changes which we came across to find out this type of change. But in this session, I will try to cover up all the changes, all the amendments which are covered in this Companies Act 2013, Schedule 3 and CARO 2020. So begin with the first one point, that is Companies Act 2013. So what are the changes which came under the Companies Act 2013? So the Companies Amendment Bill 2020, which was introduced in Lok Sabha by the Ministry of Corporate Affairs and Nirmala Sitaram on March 17, 2020, the bill was passed in 28th September 2020 by the Parliament. So just recently this bill introduced, and there are lots of amendment which is come in this Companies Act 2013, and this bill which is called as the Companies Amendment Bill 2020. So MCA, they have come up with this circular and they have changed so many sections. So I can say there are the 66 sections are amended, and 21 sections are still the pending, and 12 more sections which are notified in 22nd January 2021, two more sections which are notified in 11th February 2021. Still there are the 7 sections are pending from this notifications, like section number 4, 5, 23, 32, section number 40, section number 45, and section number 56. So total there are the 66 sections which are changes in this particular Companies Amendment Bill 2020. Now here I have divided into total 6 points, starting with number 1, that is changing in dynamics. Second, number 1 point, that is important changes in the Companies Amendment Act 2020. What are the power which delegate to central government? Next one, that is section where imprisonment removed, because in this Companies Amendment Bill 2020, I found out that there's so many sections in which they were remove the word imprisonment, and many more sections they have reduced the penalties and the fine amount. So it is like the opportunities, because in a very few of the sections only the imprisonment word are there, and many more sections are there the only penalty is a fine amount, no imprisonment words are there. So it again, it is a good opportunity. If we have missed out to file any forms, then the only fine that just we have to the fines, and after that just we file the forms, and that's it. And last one, that is the decriminalizations of the offense and reduction in penalty amount. So the starting with the very first point, that is what are the changing in the dynamics. So here I have divided into total 6 to 7 points, that are what are the changing in dynamics. Number first one, that is convergence of criminal offense to civil. As I say, that is so many offense that is now as a civil. There is no such criminal offenses are there, because there are very less sections are there, because they have the word like imprisonment, and many more sections are there, they have the reduce the words or change the words as a only fine and penalty. So it is like convergence of the criminal offense to civil. Second number point, that is the criminal prosecutions are there, because as I said, there is only few sections are there, they only they have focus about this imprisonment provisions, so very less provisions are there for the criminal prosecutions. Next one, that is the compounding of offenses are there. So there are total 66 offenses are there which are the compounding in natures. Next one, MCA compliance management system. So just recently we seen that there is all the website of MCA which are changed. So again, it is a compliance management system. They are trying to very easy this information. This is a very easy website, so anybody can go and check the information about the company. They can easily check. So this is the compliance management system is there. After that, that is artificial intelligence. They are trying to file the forms via the cell phone. You can attach the affix the DSC via the cell phone. So all this they have tried to resolve all these problems, or they are to try to file the forms via the cell phone. You can file. So upcoming the decisions which are waiting for this, and the disqualification is that KYC active strike off. Now disqualification of directors, in case if you are not filing annual return from last 5 years and you are disqualified of being directors. Once you are disqualifying being director, you cannot be appointed as director in any company. After that, that is the KYC is there. Now what is the KYC? As we all are know that every year we have to file the form, this DIR3 KYC. This KYC, in case of any web based form, just we have to put the OTP which is given on the mail ID and the cell phone number. So just we have to go there and mention the OTP of the mail ID and the phone number, and our KYC was done. So this is the DIR3 KYC. We have to file this form INC 22A for the active compliances. If our company which is not active compliant, then the various other prosecutions are there, that we have not appoint any director in that particular company. Apart from this, we cannot increase our authorized share capital. So so many possibilities are there if you have not filed this form. So that is active. Strike off, we all are know that the strike off, in case of this strike off, that is in case of any company who have failed to file this kind of annual return, and who have failed to file this kind of returns, then this ROC have a power to strike off these companies. So again, this is the possibilities are there. And the last one, that is consequences of delay in annual filing. So here is consequences of delay in annual filing. So we all are know there are the recent amendment which came. If any company which have failed to file this annual return, then they have increased the penalty amount. So the amount that is per day 100 rupees. So every officer who are or you can say who is in default shall be liable to pay the penalty of rupees 10,000. In case of continuous failure to with this, the further penalty of rupees 100 rupees each day. So again, it's our responsibility that we have to take care as much as of our clients this kind of the returns and everything. So because delay in filings, we have to pay the heavy penalty. So always we have to avoid all these things. Because if I can say that right now the due dates of filing these forms, like the DPT3 is there, DPT3 is the 30th June is the last date, CFS is 2020, the last date of filing form is 30th June 2020. So it's our responsibility that we have to take care, and we have to file all the forms on or before the due dates. Next one point, that is decriminalization of offenses. Right, what are the decriminalization offense? As I discussed with you, there are the so many offenses are there. They were removed this words like under the Companies Act 1956, all the offenses were criminal. Next one, under the Companies Act 2013 up to the 1/11/2018, 81 criminal offenses are there. Now, the company's amendment, which come further, the ordinance, one more ordinance come in the 2018. And after that, the Companies Amendment Act 2020, they were decriminalize the 26 offense and remove the 5 offense and imprisonment in the 12 cases. So there were, I can say, decriminalize, there is only the 26 offenses are there. They are the decriminalized, and remove the 5 offenses and imprisonment in the 12 cases. So they were again this removed, and only 12 cases they have only this imprisonment word. Rest of the things we can say there is a decriminalizations of offenses. And finally, the very few offenses are there which fraud shall only remain criminal. So only the few offenses are there in which the fraud shall only remain as a criminal offense. Apart from this, I can say all the offenses are the civil offense. Just we have to penalty. There is a no such kind of words they have the add like the imprisonment. So again, it is a kind of a good way to go in this company's amendment bill 2020. So we can just pay the penalties, or we can avoid, or if we are unable to file the forms, we just pay to those penalties. Now, what are the important amendment come which in this Companies Act 2013? So as I discussed with you, there are the so many amendments which is come in this Companies Amendment Bill 2020. So basically, I have divided into particular the 6 points. Now, starting with this point, important changes. So there are total 15 important changes. Now, second number 1 point, punishment by way of imprisonment, which remove through the offense remain criminal, because imprisonment words which remove from particular this 12 section. Decriminalization 26 are the sections which were the decriminalizations. And what are the powers of central government? So again, they have the they change like there are the certain power which are with the central government. So here I can say there are the total 9 sections are there in which they have power with the central government. Next one, that is punishment which remove for the offense, that is total number 5. 5 offenses in which they have removed the words as a punishment. And the last 1 point, that is reduction in amount of penalty, because as I said, that is there are the 7 sections in which they have reduced the penalty amount. There are total 26 offenses. This all are the decriminalizations, and the 12 offenses are there which is punishment by way of imprisonment, which remove through the offenses which remain criminal. So again, this are the all the basic changes which is in the Companies Amendment Act 2020. Moving forward this portion, that is the number first one, section number 23. Now in this section number 23, that is a public offer and the private placement. First changes under section 23. So section number 23, subsection 3 and subsection 4, which empowered, in which MCA empowered to allow this certain class of public company to list a class of securities in the foreign jurisdictions. So here in this section, they have insert 2 more subsection in this section number 23, and they allow to this companies, this kind of the public companies, they have to list their securities in the foreign jurisdiction. So again, it is a good opportunity to public company. They can raise the funds in the foreign markets, or they can list their securities in the foreign jurisdiction. So again, it's a good opportunity, we can say. And based on the SEBI expert committee report 2018. Next, MCA, which has empowered to determine certain class of public companies which shall be permitted to list in foreign. Both listed and unlisted public companies are here the eligible. So here the both the listed and the public unlisted companies both are eligible. They have eligible to class or list their securities in the foreign jurisdictions. Now, even a company can directly list its securities without raising this capital. So here the company can raise the funds without the raising the capital. Next one, that is MCA, which has also been empowered to prescribe the permissible foreign jurisdiction for listing of securities by the Indian companies. And simultaneously, we can check the listing on the exchange in different jurisdiction may also be the possible. So listing in the different jurisdictions, we can also be the possible in with that point. And next one, that is likely permitted jurisdictions may include these jurisdictions where masala bonds which are permitted to be issued, or jurisdiction where depository receipts are permitted for the issuance by the Security Exchange Board of India. So here the masala bonds is there, which are permitted to the issued or jurisdictions where the depository receipts are permitted for the issuance by the Security Exchange Board of India. And last one, that is MCA, which empowered to exempt any class and class of public companies opting for foreign listing from any of the provision of this particular chapter under this section 89, 90 or 127. So again, it is a good opportunity to public company if they want to list their securities in the foreign jurisdiction. They can raise the funds, they can security, they can also class of securities registered in this particular foreign jurisdiction. Next section, that is section number 170, that is 117, and the resolutions and agreements which is to be filed. Now, under section 117, which require for filing of certain resolutions and the agreements with the register of companies in MGT 14. We all are know that is the private companies are exempt for filing all the resolutions. Like if I can say that is to authorize to the buyback of the particular
Disconnect ആയോ?
I think it is disconnected. No, she's available under the panelist.
Hello, ma'am.
Ma'am,
Ma'am, you are disconnected.
Maybe she has to rejoin. That will happen automatically.
okay,
Let's mute.
okay.
So we have to compulsory file this all the forms in the MGT 14, and accordingly the terms of this provision section 170 subsection 3 subsection G, the resolution which passed under section 179 subsection 3 are also.
Your screen is not visible. I think its sharing has lost in between, the connection lost. So
Just a minute, sir.
share it again and start.
Yeah.
Okay, now it's okay.
Okay. So here we can say that is in this particular sections that is exemption from the private companies, and we have to compulsory file this form like resolution as I discussed with you, which are covered under section 117 subsection 3 subsection G, that compulsory we have to file all the resolutions with the ROC. Now the second proviso to section 117 subsection 3 subsection G, which provides exemption particular for the banking companies in respect of resolution which passed to grant loans or give the guarantees or provide securities in respect of loans under clause F in subsection 3 of subsection 179 in the ordinary course of business. So here we can say that is in section 117 subsection 3G, there is exemption given for the banking company in case of any particular transactions like grant of any loans, given any given guarantees or securities. All these are exemptions for banking company. Now this Companies Amendment Act, which has exempted, or we can say it's extended to this exemption also for the non-banking finance company, or we can say that is the housing finance companies, or to represent to exemption to banking companies by way of replacement of the second proviso. So in this particular proviso, I can say here there is an exemption given to the banking company as well as the non-banking finance companies and housing finance company. So here there is exemption given for the particular three sectors: banking sector, non-banking finance sectors and housing finance company. So accordingly we can say if they have grant any loan or given any guarantees or given any securities, they do not have to file MGT 14 with the register of company within 30 days of this particular event. Moving forward, that is again one change in under section 129A, periodical financial result. Again, they have inserted this clause, that is section 129A. So there is some new clauses, that is 129A. So what is section 129A? So section 129A, which inserted, that is class of unlisted companies, they have to prepare and file financial result with the limited review by the auditors. So earlier, they do not have this word like limited review. Here they have the add the word that is limited review by the auditors. So all the unlisted companies, they have to prepare this financial results with this particular limited review, and this limited review by the auditors. This new section 129A, which inserted to provide for the preparation, limited review and filing of financial result by the class of unlisted companies. So new section 129A, which is inserted, provide for the preparation of the financial statement, this limited particular review of report, filing of various financial statement by this class of unlisted company. MCA, which empowered to prescribe class of companies classification either on the basis of that particular capital, that particular turnovers, or the borrowings, and filing, which is compulsory required within 30 days from the completion of this prescribed period. So they have to compulsory to file this financial statement, and yes, this must be limited by the review by the auditors. So again, this is a new section inserted under section 129. So the section that is 129A. So here all the unlisted public companies have to prepare their financial statement and must be limited or review by the auditors of the company. Now, there are so many changes in this particular corporate social responsibilities in this particular CSR provisions, because in this particular provisions, they have given first of all, they have to reduce the penalty. They have to carry forward this amount towards in particular account. So again, there are the lots of changes. Total, I can say 5 to 7 changes are there in this particular CSR, that is in the corporate social responsibility. So this is the third proviso of section 135. Subsection 5, they have inserted, that is a set of excess amount spent in CSR in succeeding years. Section 135 subsection 9 inserted exemption from constitution of CSR committee. Let's explain this point. Now first number point, that is section 135 subsection 5. So again they have inserted this particular subsection. Now what was this? Again, in this particular year, if I'm talking about the previous year, that is 2021, the amount which we are spending towards the CSR, it's actually the 3 crores rupees, but we have some excess amount of funds. So we, in this previous financial year, we have spent approximately of rupees 4 crores, right? The actual amount which are going into the CSR activity is 3 crores, but we have spent some more amount. It's about 4 crores rupees. So we have spent some extra amount, that is, I can say it's a 1 crore rupees. So here, this 1 crore amount, that is, we have to carry forward for the succeeding financial year. So we can access, agar, if I can say in the this particular financial year, the amount which we are spending towards the CSR activity, it's basically 2 crores, and in previous year we have already spent excess of this 1 crores rupees. So we can set off both the points. So set off of this excess amount spent in the CSR, which is in the succeeding year, so we can carry forward this particular amount. Now in there is an exemption from particular constitutions of the CSR committee. When it's exempt, so they have inserted one provision like section number 135 subsection 5. If amount of this particular CSR activity which does not exceed this 50 lakhs rupees, so the amount toward the CSR activity which is does not exist this 50 lakhs rupees, then we not required to constitute this CSR committee, right? So amount toward the CSR, it's not exceed this 50 lakhs rupees, then we are not required to constitute this CSR committee, and the board have all the powers which are related to the functioning of this particular CSR activity. So again, I can say that that is a set of is there set of expenses set of expenses is there. We are not required to constitute of this particular the CSR constitution of the CSR committee. So again, there is a one new section inserted over here, and relaxation to carry forward and set of permitted punishment, which is converted into the penalty. As I discussed with you earlier, that is here, in case of non-compliances of this particular CSR provisions, then earlier that was the punishment is there, but now I can say there is only we have to the penalty. So here they have the remove the word as a punishment, because the punishment which is converted into this particular penalty. So again, it's a good opportunity, we can say that. And moving forward, that is total, there is a 3 change in the CSR corporate social responsibilities. That is the set of excess amount in spent in CSR activities, exemption from constitution of CSR committee, and the punishment which is converted into the penalty. There are many more changes are like that. If in this particular year, if we are unable to spend this amount toward the CSR, then we cannot carry forward this amounts. So we cannot carry forward this amount toward the next year. So that cannot be possible. So this is the changes in this particular section 135. Now, section 149, company to have the board of directors. So there is a new provisions of section 149 subsection 9, which have inserted payment of remuneration to independent directors as per schedule number 5 in case of inadequacy of profit or the losses. So now in case of any company, there are the chances, because in this pandemic situations, there are the possibilities are there. In case of any company, they have the no profits, or it's a profit which are the inadequate. Okay, so the company who have the not enough profits, or the company have the profit but the inadequate, now an independent directors may receive the remunerations and the exclusive of any fees payable and subsection 5 of section 197 in accordance with the provision of schedule 5. So independent directors may receive the remunerations if the company have the no profit or the inadequate profit, they can receive the remunerations. Now this corresponding changes has also been made in section 197 subsection 3 has also been made. So again, there is a changes in this particular independent director provision. We can say that's a particular remuneration portion. As far as concerned, independent director cannot receive remuneration. They have to only take this setting fees as well as the commission amount. So in case of the any company who have the no profit or inadequate profit, still the ID have a right to take this setting fees from this particular company. Now there are one more changes in this section number 179, that is a managerial remuneration provision. Section 170, that is 197 subsection 3, that is amended. Payment of remuneration to ID as per schedule 5, as we discussed in case of the inadequate of profit or the losses is that. Section 197 subsection 1 provides for overall all the limits as well as individual limits for the total managerial remuneration payable by public company to its directors, including MD, whole-time director, and managers, right? So here provide for overall all the limits as well as individual limits for the total managerial remuneration payable. So we can also here check that is individual limit, that is a total managerial remuneration shall not exceed 11% of the net profit of the company. And we have to check the individually, like just we have to check for the 1%, 3%, 5%. So this is the conditions are there. So we have to check, and they have to add one more inserted these provisions like after the words like the whole-time director. So they have add this word whole-time directors or the managers or any other non-executive directors, including the independent director, to bring this clarity regarding the payment of remuneration to non-executive directors or the independent directors, because as they have mentioned in the schedule number 5, in case of the any loss or inadequacy is there. Now next one, that is the producer companies is there. So this is the section number 378 for the producer companies. That is new chapter altogether they have inserted in this particular companies amendment act 2020. Now section number 378A to 378ZU, they have completely inserted these provisions for particular producer companies. The provisions which regarding this producer companies inserted by way of section 378A to 378 ZU in new chapters in the line with this particular Companies Act 1956. So again, they are planning to introduce this chapter in Companies Act 2013, but again, it's still so far it's a pending. But in this Companies Amendment Act 2020, they have inserted this type of provisions. Now, when Companies Act 2013 was enacted, it was proposed that separate enactment shall be made for dealing with the producer companies, and accordingly, Section 465, which provided for the survival of the provision of this particular of the Companies Act 1956. Now it has been made part of Companies Act 2013 to avoid obvious confusions, because here they have introduced this particular chapter, that is producer company. Here they have also introduced regarding the minutes of this producer company, what are the meetings of this particular producer companies, and what are the directors in this producer companies, what are the terms and conditions, rules and regulations. So everything for this producer companies, they have inserted in this provision, like section number 378A to 378ZU. Next one, that is section number 446B. Lesser penalties for certain companies. So here in this particular provisions, we have to pay a very less penalties. Now, section number 446, which provides that the court imposing any fine under this act may direct that the whole or any part thereof shall be applied in or towards the payment of the cost of the proceeding, or in or towards the payment of rewards to the person on whose information the proceeding were instituted. So here they have reduced the 50% amount, 50% of this penalty, which were reduced in case of section number 92 subsection 5, 107 subsection 2 and 137 subsection 3 by OPC and the small companies. So again, I can say that is a good opportunity for the OPCs and this particular the small companies. In case of they have a default in filing the annual returns, default in conducting any meetings, etc. So they have to, in case of any non-compliances, so they have to pay just 50% amount of penalty. Now changes benefit of 50% of penalty, which extend to all the offenses under the act and to startup producer company in addition to the OPC and small company. Further, maximum penalty for company cap it's ₹2 lakhs and for the officer is 1 lakh. So here a maximum cap they have mentioned in case of default in filing of forms or defaulting filing this annual return. So they have cap. So here they have specified this particular cap, like I can say that is the maximum penalty for the company, which is maximum, it's a 2 lakh, and for the officer in default they have only this 1 lakh rupees. So again, the lesser penalty for the only OPCs and small companies, not for all the companies. And in case of any small companies and OPC, they have failed to file this annual returns, and if they have failed to file this annual return on this particular due time. Now next one, that is again this is a good provisions and important to learn this provisions, because we have to see so many cases in our day to day for this like I can say the non-filing of annual returns. We have seen that so many companies are not filed their annual return in last 10 years, 15 years. So here the ROC was given one time opportunity till the 30th September 2020, but after that there are so many companies are that there are failed to file this all this returns and everything. Now here I can say that is adjudication of penalty. Now what is this new provisions, why they have inserted this provision? So section number 454 subsection 3, which have amended quantum of penalty to be levied in this adjudication. Now what is this adjudications? So here this is the new proviso which is added to provide, that is no penalty shall be imposed for default under section 92 and section 137. So in case of any default, which is filing of this annual return and filing of annual financial statement, there is a no penalty shall be levied if such default has been ratified prior to or within 30 days of issue of notice by the adjudicating officer. Let's take one example to clarify this particular section. Now, what they are trying to say, in case of any company who are failed to file the annual return like the 2018, 19, 19, 20. So if they are unable to file this annual return and the financial statement. Now, adjudicating authorities or adjudicating officers are there. They have, first of all, they have to send the notice to your company. You are unable to file the returns and we have to given this particular days, like the 30 days time period is given. Now, if you are filing this written within 30 days after the issuance of this particular notice, and if you have filed this annual return and the financial statement within this particular stipulated time period, you are not give, or you are not supposed to pay any penalty for this particular annual return and this annual financial statement. So again, this is a good opportunity, because if we file all the annual returns and all the audited financial statement within 30 days, we have not filed any penalty, or we are not filed any penalty towards this particular default under section 92 and section 137. So again, this is a good provisions, that is, again, they have specified that is no penalty shall be imposed for default under section 92 and 137. Now, in section 454 of the Principal Act, in subsection 3, the following provision shall be inserted, the namely, that is provided that in case the default which relates to non-compliance of subsection 4 of section 92 or subsection 1 or subsection 2 of section 137, and such default has been ratified either prior to or within 30 days, or within 30 days. So if we have filed the return within 30 days, the issue of the notice by the adjudicating officer, no penalty shall be imposed in this regard, and all the proceedings under this section in respect of such default shall be deemed to be concluded. Next one, that is there are the certain power which are delegated to central government. Now let's discuss what are the power they have delegated to this particular central government. Now, number first one point, that is prescribe certain class of companies in consultation with the Security Exchange Board of India for the exemption from the category of the state company, which is specified in section 2 subsection 52. So here all the power which is given to the central government. Next one, in case of prescribe, which is lesser number of days of for offer of the period for the right issues, in case of any relaxation for making declarations for the beneficial interest on section 89 subsection 11 is that they have given all the delegation power to the central government. Next one, that is prescribe the class of companies. As I said, that is unlisted company, they have to file this financial statement with the limited review report. Next one, set of the excess amount, just we have discussed in the CSR provisions, excess amount that we have to carry forward in the next year. So set of this excess amount spent in the succeeding years in terms of the proviso to section 135 subsection 5. Exempt class of foreign companies from the compliances under section 393A, newly inserted previously was provided in proviso to section 379 subsection A, which is now deleted. So here the foreign companies provision is that they have deleted these particular provisions, and they prescribe the higher additional fees for default on 2 or more occasion in term of the third proviso section 403 subsection 1, which is replaced. Established benches of NCLAT in terms of section 418A, which is a newly inserted. So there are so many NCLT benches they have introduced in this particular 4188. This NCLT benches is for the resolving all the problems like the insolvency cases is there, or right now the new cases, this is in case of the personal insolvency is there. So they have increased this benches, that is NCLAT, that is National Company Law Appellate Tribunal. Now sections where imprisonment removed. So as I discussed with you, there are the total 12 to 15 sections are there. They have removed the word like the imprisonment, right? Number first one point, that is default by section 8 company. In case any default in under section 8 company, like in case of the non-compliance of any provisions or the default in fulfilling the object laws or license, in case of any non-compliances under filing forms or anything else are there. So anything else which is related to section 8 company is there. So here I can say that is here the word which is imprisonment which is removed. So this offense which is remains the criminal. So punishment by way of imprisonment which is removed through the offense which remain criminal. And issued the prospectus in case of any contraventions in the contravention the provisions of the issuance of the prospectus, in case of any defaults in the listing provisions, and in case of any non-compliances which are for the buyback of any securities. So we can say that the here is again criminal offenses are not there. After that, that is default in maintenance or allowing inspection of books of accounts, right? So in case of any company who are not maintain any books of accounts, so here there is a no such type of the criminal offenses are there. Non-compliances in case of the provision relating to the audit and the auditors under section 147 subsection 1 and 2. So like the provision for the appointment of auditors or any non-compliances which are done by the auditors, so there is a no such kind of the criminal offenses are there. There is like the civil offense, because here they have the remove the word as a imprisonment. Default under section 167 subsection 2 by continuance as a director after the vacation. So vacation of director is there, and if they are continuing after this default, so it's not imprisonment. In case of the case, it's like the operation and mismanagement of the case, or in case of any company who are not fulfilling their objectives, or they are the alteration in this MOA or the article of association, contravention in this alteration of AOA and MOA, there is a no such penalty. There is only the penalty. Here there is a no such imprisonment. What is that? Next one, acting as a managing directors in case of the contravention. So in case of any activity which are doing by the managing directors, or in case of any contravention of this particular provisions, which are again, it's not imprisonment. Disposal of books against the order of NCLT or as provided in the rules under section 347 subsection 4. Any non-compliances by the foreign company. So again, non-compliances of foreign company, it's not the imprisonment, just we have to pay certain amount of the penalty. And the non-compliances of order of the compounding authority, because there are so many compounding offenses are like that. In case of we are not holding AGM as on due date, so just we have to file this compounding offenses. So in case of any compounding offenses are there and we are non-complied of this particular order of this compounding authority, there is a no such imprisonment are there. So here there are, I can say that there are total 12 sections are there in which the imprisonment word which were removed, there is only the penalty. So just you have to pay the penalty in case of any non-compliances in this particular 12 section. Moving forward, that is decriminalization, right? What is this decriminalization? So in this decriminalization offenses, I can say that is punishment. There are the certain punishment. Is there punishment for the penalties? There punishment for the imprisonment is there? But in this decriminalization offense, there is an in case of non-compliance of any of these things, just you have to pay the penalty. Here again, they have to remove the words as an imprisonment. Now, what are they? Number 4, that is the punishment for the non-compliances regarding the transfer or the transmission of shares under section 56 subsection 6 is there. So the punishment for the non-compliances in case of any default in the transfer and the transmission, in case of any non-compliances regarding to say the creation of the charge, modification of the charge, or satisfaction of charge, if we are failed to file this form CHE1, CHE9, etc. In case of non-maintenance of register of member under section 88 subsection 5, in case of non-declaration of beneficial interest by the register holder or the beneficiaries under section 89 subsection 5, in case of any non-filing of the beneficial interest by the particular company, non-compliances regarding that is SBO, beneficiaries owner, this particular provision is there. In case of the non-compliances are there, this all are the provision where there are, I can say there is only and only the punishment is there, and just we have to pay the penalty in case of the non-compliances is there. Punishment for the wrong certification by the PCS under section 92 subsection 6, as we all are know that in particular the annual return, the signature is a compulsory, either the company secretary of that particular company or the company secretary in practices. So in case of any wrong certification are there, so just we have to pay the penalty. There is no such imprisonment word is that. Punishment for the sending invitation for the appointment of the proxies at company's expenses under section 105 subsection 5 is there. And the punishment for non-compliances regarding unpaid dividend or the transfer of shares under section 124 subsection 7. So punishment for the non-compliances, or we can say the punishment for the transferring this unpaid dividend, unclaimed dividend, or the transfer of shares are right now decriminalization of offense. We do not have to pay the any penalties. We do not have to, like, the imprisonment word is removed, and just we have to pay the penalty. Now there are the certain sections are there. What are this section? Like total 7 sections are there, in which the word which is penalty, they have reduced this penalty in this particular section. Now what are this particular section? That is, I can say that is section number 64 subsection 2 is there. 64, that is alteration of share capital is there, in which they have reduced the penalty amount. 92 subsection 5, that is annual return, again they have reduced this penalty amount. 117, that is for resolutions and the agreement which are to be filed with the registrar of companies, they have again, in which the penalty amount they have reduced. 137 subsection 3, that is a copy of the financial statement must be filed with the registrars, they have reduced the penalties. 140 subsection 3, that is the removal and the resignations of auditor. And 143 subsection 3, that is powers and duties of auditors and the auditing standards, again they have to reduce this the penalty amount. And 165 subsection 6, that is the number of directorships, that is, as we know, that is a specified number which is given. 20 public companies, total 20 all the companies, we cannot become director more than 20 companies. So in all these particular sections, they have reductions in this particular penalty amount. So we can see in this company's amendment bill 2020, they are more focusing on this portion, like the reduction in the penalty amount. So many sections they have removed the word is a imprisonment. There are more sections, there are only the civil offenses are there. So again, this is a good benefits, as a good opportunities. In case of any non-compliances, there is no such words of imprisonment, just we have to pay the penalties, and we have to just file the forms with the penalty amount. So this is all about the major changes that I can found in this Companies Amendment Act 2020. There are more changes are there, that is which are effective from 1st April 2021. So what are the amendment which are effective from 1st April 2021? So starting with this point, I can say that is changes in the definition of a small company. Now here they have changed the definition of small companies. So this is the notification which is dated 1st February 2021. Small companies other than which is public company, which are from the 1/4/2021. Now what are the changes? So paid up share capital of the company shall not exist rupees 2 crores from rupees 50 lakhs. So the maximum remains same as rupees 10 crores. And the turnover of company shall not exist 20 crores, which is from 2 crores. So turnover which shall not exist 20 crores, and maximum which is, I can say, that is 100 crores. So that can be possibilities are there. So this is the definition of small company, and they have changed the paid up share capital ratios and the turnover ratio. So this is like the changes in the definition of small company. There are also changes which is in the concept of one person company, definition of listed company. Again, this is the applicabilities of a new CARO, that is Companies Audit Report Order 2020. Because earlier this CARO which is applicable from 21st April 2021, but due to 1 year extension, now the CARO which will be applicable from 1st April 2021. Financial statement schedule number 3 with the new clauses are there. So they have inserted some more new clauses in this particular schedule 3. We will discuss in later portion, that is CARO and schedule 3. What are the changes again in this particular schedule 3 and CARO? Disclosure of directors report. Now again, there are the few changes in the disclosure of directors report. We have to add some more points in this particular directors report regarding to, say, if I can say, like the CSR committee particular, the CSR provision is there. So just we have to add in this particular portion in this director report in case of non-constitution of this particular committee. After that, in case of any ongoing cases which is under the insolvency and bankruptcy code, report. So any company which is under the CIRP process, so we have to compulsory mention that this company which is in the CIRP process. So this all are the changes in this particular disclosure of this particular director's report. Now, disclosure of audit report, which are covered in this particular schedule 3 and CARO. So I will cover this particular in this point. An annual return of OPC and small companies. So there are the few changes, major changes, which I found out in this particular form MGT-7. So here the ISIN of the equity shares of the company to be mentioned at the end of the table of the share capital, debenture, or the security company. So nowadays, I can say it is a compulsory that we have to mention this ISIN equity share of this particular company in this particular form MGT-7. Apart from this, that is the names, addresses, countries of incorporation, registration, and percentage of shareholding held by the FII, that is foreign institutional investors FII, to be given at the end of the table shareholding pattern. So in this MGT-7 form, you have easily find out that is information for shareholding pattern of all the promoters or the public the FII. So just we have to add, they have to add one more point, that is shareholding by the FII, foreign institutional investors. Now, apart from that, that is two additional points they have inserted in the certification of this form MGT-7. The company has not issued any securities to the public. So in case of company who has issued any securities to the public, so just we have to click on yes. And total number of members which are not exceeding 200 in case of the private limited company, because we all are know that the private companies are compulsory, they have the minimum 2 members and maximum 200 members. So the private companies members cannot go beyond 200. So just we have to click on this particular point. So this all are the major changes in form MGT-7. And this already I said that that is regarding to say this small company definition. One more thing that I would like to discuss with you, that is a central scrutiny center. Now, what is a central scrutiny center? This MCA which established, that is central scrutiny center for scrutiny of STPE forms. There are certain forms, like I can say that is form DPT3 is there, MSME form is there, DIR 12 is there, INC 20, that is shifting of registered office, appointment of director, that is we have to file this DIR 12. And that is a form I just said with you, that is a CHG1 form is there, CHG9 satisfaction of charge, registration of charge, INC 22 shifting of registered office is there, INC 22A form is there. So there are so many forms are there which are basically the STP mode. STP, that means straight through process. Now, straight through process, that means without checking your documents, without the checking of your form will be approved. Now here the MCA which will introduce this is the CSC, that is a Central Scrutiny Center. Now, what is CSC and how it's a work? So on March 18, 2021, that is a MCA which has established for this, and which has established for the Central Scrutiny Center, that is the CSC, under the administrator or control of e-governance cell of the MCA. This CSC shall carry out scrutiny of e-forms which is filed at STP, that is straight through processes, and forward their findings to the concerned jurisdiction ROC. Now, ROC shall then prosecute the defaulters, and ROC will initiate these actions in case of they have to find out any discrepancies, or in case of any problems, or in case of defaults in this particular filing of this particular attachment, or in case of the documents, or given any fraudulent information, anything can be possible are there. So ROC shall then prosecute and then defaulter and initiate this particular sections. Now, this particular establishment of this particular CSC, I can say that. Now, what is this? Establishment of CSC, the challenge which is faced. Now, any e-form which is approved through STP which I said that is e-form STP, that is form number NC22A, DIR 12 is there, and MGT-7, EOC4, many forms are there. All the forms I can say that is maximum are the STP modes is there. So any e-form which is approved through the STP or later within 8 years found as a defective. So after 8 years, if ROC has found any defective in your form or by this particular CSC, that is Central Scrutiny Center, reporting will be made to the ROC and ROC shall send the notice to file e-form or document of fresh along with the fees and additional fees within 30 days timeline. So again, we can say that after filing this particular form, so here the time period which is 8 years. Now, in case of CRC, that is the Central Scrutiny Center. Now, if CRC, which will find out any information which is incorrect or anything which is wrong information which is given in this particular form or any incorrect information in this, right? So the form which is defective. So here the CSC, that is Centralized Scrutiny Center, they have give this particular report to the ROC, and now ROC which will send the notice to this particular company and they have to file this form again with the additional fees, and they have to again give the timeline of 30 days timeline that is given. Now no opportunity of resubmission or rectification of the defect will be given. So here there is a no opportunity of resubmission or the rectification of this particular error or the defect will be given. So there is a no such kind of opportunity is given. There is a only opportunity therefore one time. So here we have to file this form only and only for the one time. Second number challenges that we have faced, that is any form other than STP, that is other than this straight through process. ROC will be sending notice and opportunity given to the company to rectify and resubmit the form within 15 days. Now here we have to file this form again within 15 days time with any fees or the additional fees. And ROC through this CSC may open e-form file earlier in the STP mode up to past 8 years, which is effective from 23rd May or March 2021. So other than STP form is there, so we have to submit this form within a 15 days timeline is a given. We have to pay the penalties and we have to pay again the additional penalties or additional fees. ROC which through CSE may open e-forms filed earlier, so anytime they can open our forms, anytime they can check our forms which are filed through the STP or non-STP, anything can be possible. But here the timeline is 8 years. If beyond the 8 years is that, they cannot accept it at all. So here the timeline is this checking all this information. It's a particular, the 8 year is given. And again, it's effective from 23rd May, March 2021. So again, this is all this changes I can say, which is amendment, which is effective from 1st April 2021, starting with the definition of small company, concept of one-person company, definition of listed company, again they have to change, applicability of new CARO, what are the changes in the schedule number 3, there are the certain disclosure that we have to mention in the director report of particular financial year 2021, disclosure which is again given in this auditor's report, annual return of OPC and small companies, just we have discussed, they have changes this annual return and OPC of the small company, and CSR in case of exceed the amount, just we have to exceed the amount of a CSR, then we have to carry forward or set up this amount in the next year's CSR constitution committee. In case of the expenditure which is not exceed 50 lakhs rupees, then at that time we have to not require to constitute CSR activity. So here there are the so many provisions are there for particular the CSR activity. Now, the second number of our point, we have just discussed about all the amendment which is in the Companies Amendment Act 2013, or we can say the Companies Amendment Act 2020. Now, we are going to discuss recent amendments in the schedule number 3. Now, schedule number 3, as we know, that is the Ministry of Corporate Affairs, Government of India, which issued the notification from 24th March 2021 regarding to certain changes in the schedule number 3 and the company's accounts rule 2014 and company's audit and auditors rule 2014. They have to enhance the disclosure required to be made by the companies in its financial statements, in its board report, and the audit report, etc. The aforementioned notification shall come into the effect from the first day of April 2021. So here, this notification, which will be effective from the 1st April 2021. Now, this is again this particular amendment in Schedule 3. They are more focusing on this portion like the details of the shareholdings of the promoters, loans and advance which is extended to the promoters, directors, key managerial personnel of the companies, any details which is regarding the Benami transaction is there, or many more which are there. They have to disclose certain ratios or many more ratios in this particular schedule number 3. All these are the major changes in this particular schedule number 3. Starting with this first point, that is, I can say the rounding off is there in the schedule number 3. Now, depending upon the total income of the company, the financial statement are to be mandatory rounded off the nearest. So we have to round off for this particular provision in the nearest unit. As mentioned in this particular schedule, rounding off like less than 100 crore rupees is there. So it's just we have to rounding off by nearest hundreds or thousands or lakhs or millions or the decimals thereof. In case of which is 100 crore rupees or more, just we have to round it off with the nearest lakhs, millions, crores or the decimal thereof. So we have to rounding off this particular amount. And prior to this amendment, there is a voluntary in case of any person who can adopt this is a voluntary basis for the companies preparing their financials as per companies accounting standards from 2006 and the nearest unit which was based on the turnover of the company. So again, it is a completely rounding of particular all the transactions. Next one, that is notes on share capital. Now, notes on share capital, again, it is a compulsory earlier in our balance sheet. Just we have to show the shareholding pattern of all the promoters or all the shareholder in case of which is more than 5%. Now, after the amendment, we have to compulsory disclose the shareholding of all the promoters unless or in case of any changes which is less than 5% is there, still we have to mention the shareholding pattern of promoters or anything which is changes in the shareholding pattern we have to disclose in this particular our shareholder in this particular table. You can see here that is shares held by the promoter at the end of the year or any percentage which is a change in the during this particular year. We have to mention the promoter's name, number of shares, percentage of total shares. So here we have to compulsory disclose the shareholding of all the promoters. No matters if the percentage which is less than 5%, then still we have to compulsory disclose the shareholding of all the promoters, and details shall include the change in the shareholding taken place during this particular year. So here the notes on this notes on the share capital. Third one, that is in case of statement on changes in equity. So here I can say that is we have to disclose the previous reporting period as well as the current reporting period. So the disclosure shall be made regarding the changes in the equity due to prior period errors and restated balance at the beginning of the reporting year. So in case of any changes in equity, because during the year in case of changes in the authorized share capital or either in case of the changes in the paid up share capital of the company, so just we have to mention everything in this particular tabular format. Next one, reclassification of current maturities of the long-term borrowings and the securities deposit is that. So here I can say in case of the short-term borrowings, current maturities of the long-term borrowings, just we have to show in this particular head like the short-term borrowings. Earlier, we have to mention in this current other current liabilities. Next one, security deposit maintained with the company shall be reclassified as other non-current asset instead of long-term loans and advances. So securities deposits are there, they have to maintain with the company. Earlier we have to classified with this long-term loans and advances, but nowadays we have to classified with this other non-current assets. So this is again a very small changes in this particular schedule number 3. Next one, that is a note on trade payable. So the companies that fail to make payment to companies under MSME Act 2006 or which had made any delayed payment to a MSME. So anything which is found out by the company or delayed payment to particular this MSME sector or MSMEs enterprises, or just we have to add this particular tabular format. So outstanding amount to pay due date from this payment MSMEs, or in case of any disputed dues is there, MSME disputed dues others less than 1 years, 1 or 2 years, 2 or 3 years, more than 3 years is that. So outstanding for the following periods from the due date of payments and the total amount. So the total amount which we have to compulsory mention. So here notes on trade payables. So in case of any amount towards outstanding towards this MSME enterprises and the MSME sectors, so just we have to add this amount in this particular tabular format. Note on property, plant and equipment and the intangible assets is there. So here is again the good point to discuss in case of any property, plant, equipment. Earlier this is all are the tangible assets is there, or any changes in this particular three, property, plant and equipment, or the changes which is due to this particular revaluation is there. So now any changes which is more than this 10% is there, then we have to show in our balance sheet portion. Now the note that is an intangible asset shall additionally disclose the amount changed due to this revaluation, or what are the reason why they have to change, or what are the changes, or because the changes which is more than 10% of this thing. So the changes which is 10% or more in the aggregate of the net carrying value of each class of the intangible assets is there. Now next one that is note on the long-term trade receivable is there. Now the note on long-term trade receivables. Now just we have to discuss that is note on long-term trade receivable is other non-current assets due for the payment by the companies shall consist again the schedule as follows. So just we have to go through this tabular, that is in case of any amount which is outstanding towards or the due date of this particular payment. So here just we have to mention in this particular table, that is long-term trade receivables. Undisputed trade receivable which is considered as a good, this is doubtful, disputed trade receivable is there. So everything just we have to mention in this particular tabular format. Now next one, that is in case of any loans, or in case of any loans or advance which is given to either the promoters or the directors or the key managerial personnel is there. So loans and advance to the promoters or the directors or the key managerial personnel and related parties. So when company which are given to any loan, for loan and advance to given to their particular promoters or either the directors and key managerial personnel or other any related parties, then they have to disclose in particular schedule 3 format, and they have to compulsory disclose in the separate in the financial statement, that is the types of the borrower like the promoters, the directors, the KMPs, related parties, etc. So the what are the amount of loan and the percentage of the total loans in advance which is in the nature of loan. So again this is the compulsory point. Now next one, that is point number 9, that is utilization of the borrowings. So again it is a good point to discuss over here, that is where the company has a borrowing. So when the company has borrowing from the bank or the financial institutions, and so they have to check whether this particular loans are fully utilized or not, because sometimes what happens that they are taking the loan from this, and after that we have to find out any mismatch or discrepancies is there. So just we have to disclose in our schedule 3 point, and it is a clearly state that the auditor, they have to find the difference between the statements filed by the company in that particular books of accounts, or in case of any difference in this reconciliation statement which is need to be prepared. So in addition to the above, where the funds borrowed by the company from the bank or financial institutions a specific purpose is not used for the same purpose. So just we have to check whenever they are taking this loan from the bank or the financial institutions, so they have to check whether they are using or utilization from this specific purpose or not. So it is again we have to verify this point. Now the disclosure of various ratios, like the company, they have to disclose these ratios, like again this is a new point, current ratios, debt equity ratios, that is trade receivable turnover ratios, net capital turnover ratios, net profit ratio, return on capital employed, return on investments, and various other ratios are there. We have to compulsory disclose these ratios in the financial statement. And in case of any changes in this particular ratio, which is more than 25%, then we have to give reasons, or this we have to give an explains what are the reason behind that. So this is the disclosures in this particular ratio. Next one, that is details on this Benami properties. So the details in this Benami property held and the relationship with the stock of companies. This is all this change in the schedule number 3. So in case of any Benami property which are held by the companies, or in case of any proceeding which have been initiated or the pending which is against to the company for the holding any Benami property, and the company they have to disclose various details of this property. They have to given the reason of not, which is mentioned in the books of accounts or not, what is the nature, what are the status for the same. So everything they have to disclose in this financial statement. Apart from that, if in case of any company who have any transaction with the striking of company, transaction, like I can say, like in case of the shareholding with that particular strike of company, if any director or director in this particular strike of company, in case of investment which is held in this particular strike of company, or in case of any receivables or payables in their investment in securities are there, shareholding pattern, shareholding is there, investment is there, anything is there which is with this particular strike of companies are then just we have to disclose in this particular schedule 3, or this particular point, like this particular company have the relationship with this type of company relation, as I discussed with you, securities, receivables, payables, shareholdings, etc. Anything can be possible. Next one, that is willful defaulters and other amendments. I can say that is a company which is categorized as a willful defaulters, because if any company who are unable to pay the loans of banks and financial institutions, so they can be treated as a willful defaulter. So a company which is categorized as a willful defaulter by any bank or financial institutions, they have to require to disclose details regarding the date of declaration as a willful defaulters and the amount of the nature of the default. So when it declares a willful defaulter, so just we have to mention the date, the amount, and the nature. Details and reason for the pending registrations of creations or the satisfaction of charge with the ROCs beyond the statutory time period. So in case of any details or the reasons of the pending of the registration of the creation, or in case of the registration of the satisfaction of charge is there, ROC which is beyond the specified period, a company which is non-compliant with any provisions like the two-layer investment company is there, or in case of books of account, in case of approved by the scheme of arrangement and accounting standards. So this all are the small little bit changes in this particular schedule 3. Apart from this, major changes I can say, in this particular provisions, like shareholding pattern of that in case of any willful defaulter is there, or the third one I can say the major, that is Benami property, or in case of the any relation with this particular the strike of a company is there, then we have to compulsorily mention in this particular the schedule 3 provision. So again it is compulsory that we have to, the small changes are then we have to compulsory disclose everything in this particular schedule 3. Now moving forward, this is all about the changes in the balance sheet. Now what are the changes in the particular profit and loss account? So number first one point, that is the undisclosed income is there. So in case of any undisclosed income by the company, in case of because in case of any auditor who is not founded in the books of accounts, and after they have to find out any undisclosed income or identify this particular income of the year or the tax assessment in this particular income tax, then again they have to specify this undisclosed income. CSR disclosure is there. So additional disclosure which is given for the CSR disclosure, or in case of during the year, if company have a purchase in cryptocurrencies or the virtual currencies there, investment in this crypto virtual currencies, or in case of any profit which is come from selling of this cryptocurrency and virtual currencies, then they have to compulsory disclose in schedule number 3, because under the head of the profit and loss account. So again it's very compulsory that we have to disclose over there. Now third important portion, that is a CARO, that is Companies Audit Report Order 2020. So as I discussed with you earlier, in that is, it is again compulsorily, which is again compulsory applicable from the 1st April 2020. But due to this pandemic situation, they have extended this period for the 1 year, and now which is compulsory applicable from 1st April 2021. This is a CARO, which is a new format for the issue of the audit report in case of the statutory audits. In case of the statutory audits of the companies under the Companies Act 2013. Now, CARO 2020 is applicable for all the statutory audits, which is commencing on or after the 1st April 2021. This order is applicable to all the companies which were covered by the CARO 2016. Accordingly, there are certain companies which are exempt from the applicability of this particular CARO 2016. Now, what are this company? Like the OPC 1% company, small companies are banking company, insurance companies are companies registered for the charitable purpose. So Section 8 companies are. So this all are the companies like 1% company, small company, banking company, insurance, and the charitable purpose. So this all are the companies which are excluded from the purview of this CARO 2016. And again, it is applicable from 1st April 2021. Now, there are the provisions they have changes in this particular CARO 2020. Now, reporting the requirements of this particular, the fixed assets, reporting requirement on the physical verifications, physical verification of the inventory at reasonable interval by the management, and the material discrepancies. Now, in case of a reporting requirement like the fixed asset, like the any property is there, any plant, any equipment, any intangible assets is there. So whenever the company which is maintaining, so it's a responsibility of the company, they have to maintain all the informations, and they have to maintain all the informations, as well as a reporting must be requirement on this particular of the fixed assets. So again, they have to compulsory requirement to disclosure of this particular the fixed asset, and whether the company which is maintaining the proper records showing the full particulars, including the quantitative detailed situations of the property, that the plant and equipments, everything. So which is covered under the reporting requirements on its fixed asset. Next one, that is a fixed asset additional declaration they must be required to given. Next one, reporting requirement. So it's a responsibility of auditor. They have to physically verify whether the all this fixed assets, so the inventories at reasonable interval by management, or in case of any discrepancy has been found, so they have to again mention in this audit report. Reporting requirement for granting any loans or advances to the companies, firms, LLP, or any other parties. Now, in case of any company which is given loan to any other companies or any other firms, partnership firms, or the LLPs, or any other related parties, or directors, or any other persons, they have to must be given reporting under this particular CARO 2020. Reporting which is requirement on the compliances of provision of 185 and 186 of the Companies Act 2013. This is the provision like the loans and investment made by the company. Now, in case of any company which is again the investment in other entity or investment in other companies, LLP, etc. So they have to disclose in this particular CARO report. So it's a responsibility of auditors that they have to mention each and every information in this particular CARO report. As I discussed with you, like reporting requirement of the fixed assets, physical inventories, like granting of loans, advance of the companies, firm, LLP, compliances provision like under section 185 and 186, any reporting which is requirement of compliances with the Reserve Bank of India, which have the given directions. So we have to given this particular kind of the reporting requirements of the maintenance of the cost records, reporting requirements of the any statutory dues, reporting which is a requirement of the statutory dues or any pending statutory dues like the EPFO, provident fund is there, pension fund is there, insurance fund is there, ESIC is there, etc. So in case of reporting statutory dues which is pending which is pending towards that the company are unable to pay on the properly time period, like the GST, goods and service tax, etc. Reporting which is a requirement with respect to the transaction which is not recorded in the books of accounts. So in case of any transactions which are unable to find out, or any transactions which are unable to find out in this particular records in the books of accounts, then the auditor have a responsibility that they have to given this records in the, they have to must be disclosed everything in this particular CARO report. Now when I discuss with you that is the physical inventories point, then they must be provide this opinion or the appropriateness in case of procedure for the physical inventory verifications by the management, etc. So here again it's important in this physical verifications, because whenever during at any point of time or in any year the company has been sanction this working capital limits in excess of rupees, I can say the 5 crores, or in aggregate that amount from the bank or the financial institutions, or from the bank or the particular financial institutions, then the quarterly, so financial institution on the basis of this particular security of the current assets, whether the quarterly return statement filed by the company with such or the bank or the financial institutions, they have to completely check all this information, whether the informations are the properly filed or not. Now reporting which is a requirement on the default in the repayment of the loans and the other borrowings or the interest thereon. Like in case of here, I would like to say in case of, as we discussed earlier, willful defaulter is there. In case of willful defaulter is there, then we have to mention in this particular schedule 3. Now in case of any company who are unable to pay their loans, unable to pay this loans on the particular stipulated time periods, then they have to must be given this kind of reporting requirement in this CARO report, because the company are unable to pay the loan in this particular stipulated time period. So it is a responsibility of auditors, so they have to disclose each and every part. Now next one, that is reporting which is transactions on the transaction which is a related party. Now reporting which is requirements on the related party, I can say that related party, so the related party which is a related party under the provision of the Companies Act 2013, as well as the SEBI LODR regulation is there in case of the listed entity is there. So just we have to check related party, their relation with this particular company is there in case of any transaction which is related party, just we have to disclose in this particular format like the related party. Reporting which is requirement of the internal audit system is there. So in case of the company who have it's a responsibility, they have to check, auditor have a responsibility, they have to check each and every information of this particular company. And internal audit system, just this is like the reporting must be required for this internal audit system. So internal audit system, just we have to regularly check whether the company is a non-compliances or not disclose any information in books of accounts, or whether the company have any miscellaneous, or I can say the inadvertent information that you can find out. So the company must have the system of this internal audit. Internal audit, just we have to check for the quarterly or monthly, so we can track record on that. Next one, in case of the money which is raised by the IPO, initial public offer, or the further public offer, or the preferential allotment is there, private placement or the convertible debenture, either any of the following cases are there, then we have to check all these informations, and whether company any of the following, they have to raise the funds any of the following, like I can say IPO, FPO, convertible debenture, and the preferential allotment. So just they have to check whether the all the information they have to mention at the time of IPO, FPO, or they have a fully useful this object of this particular IPO or FPO or not. That again everything that must be included in this CARO report. And the reporting is a must be requirement on the non-cash transactions with the directors or the person connected with him. So in case of any reporting transaction, non-cash transaction is that non-cash transactions with the any of the directors or person connected with him, or reporting in case of any find out cash losses during the year, or Reporting is a must be required for the resignation of statutory auditor, because some of the time the casual vacancy arises in so many companies. So here we have to given the proper reason and justification for the reason of the resignation of the statutory auditors. Reporting on the uncertainty of the companies capable of meeting its liability, because many of the time it's possible that the uncertainty of company capable of meeting its liabilities, they are unable to meet up the liabilities, they are unable to pay these liabilities. Now what are the reason behind it, they have to must be disclosed. Reporting requirements and transfer of unspent CSR amount to funds specified in schedule number 7. So in case of here again, this is a new provision, transfer of unspent amount is there. So in case of any particular year company has not spent any amount toward the CSR activity, then they have to carry forward this particular amount toward the schedule number 7. And again they have to open one more account, this is unspent CSR account. This is for as I discussed with you, in case of any particular year company have not find out any good project or good project towards this particular CSR amount, or spending this particular towards the CSR activity, then the company have transferred this unspent CSR amount towards this particular 7 or particular this particular bank account. Reporting which is a requirement on qualification and advance remarks which is given by the auditors. In this particular, the CARO reports of the companies, which is included in the consolidated financial statement. So here they would like to say any which is uh, reporting which is amount requirement on the qualifications or the advance which is remarks by the auditors in the CARO reports of the companies which is included in the consolidated financial statements. So again they have to completely disclose all this point in this particular the CARO 2020. So again it is a compulsory required to disclose each and every point in this particular the CARO report. So this is the clauses of CARO 2020. So number first one, reporting requirement of the fixed assets, physical verifications of the inventory. So we have to check whether the physical inventory, in case of the discrepancies there, so we have to again mention in this CARO report. In case of the company which is granting any loans or advance to the company's firm, LLP or any other parties, or in case of any reporting which is compliances which is a provision section 25 or 96 of the Companies Act 2013, any reporting which is a requirement for the RBI, that is Reserve Bank of India, maintenance of particular the cost records, in case of reporting which is requirement for the particular statutory dues, or reporting which is requirement with respect to transaction which is not recording the books of accounts, or the cash losses, or the any transaction with the related parties, internal audit system is there, non-cash transaction with the director or connected persons, any resignations of the statutory auditors, or the in case of the uncertainty of the company capable of meeting its liabilities, unspent amount toward the CSR in schedule number 7, and all these points, all these small changes are there which is in the CARO report. So the whenever auditor has to prepare this CARO report, they have to check the very small informations which is given, or the which are the small changes which is in this CARO report. They have to also take care, because there are the so many changes in schedule number 3, because there are the so many tabular format are that you have to edit in this particular schedule 3. So just we have to check the shareholding pattern of that particular company, trade payables, trade receivables, Benami property transaction, relationship with the strike of companies, that heads, because nowadays the head of this particular, it's again it's a changes. So just we have to check all this information. Now I would like to say, in case of any questions from your sides, or in case of any doubt in particular sections, you may ask the questions, and I hope so I will resolve all your doubt related to any Companies Act 2013 schedule 3 and the CARO 2020, and I hope you all have enjoyed this session.
Sir, Sunil Babu sir,
Sir, I asked, posted. Anybody, any questions, please?
so far questions were not there, only I don't think so. There is no questions at all. They are all.
If anybody interested to ask questions, it can directly ask now.
Since there is no response. Dear friends, anybody wish to ask any questions, please either raise your hand so that we can unmute you or give the option. Or please type in the Q&A or chat box.
No one, sir.
Yeah, one question has asked. Can I read it, Sunil sir?
Yeah, please.
Can you please clarify change in cost records in CARO? One question has come from Mr. Shankar Ram.
Okay, just a minute, sir. Can you please clarify the change in cost records? Just a minute, sir. I will explain. In which point? Because there is no such reporting requirement maintenance of just a minute, sir. This is the cost records. It's for whether the maintenance of cost records has been specified by the central government under subsection 1 of 148 of the Companies Act, and records have been made and maintained. This is only for the central government. In case of any audit like by the central government under the central government rules and regulations, so this is for this particular cost audit.
Okay, any other questions?
One more has come in the Q&A. Whether
Yes.
a cost audit is needed for government companies of Kerala.
Okay, I said that we have to read for that particular section 148. In this particular provision, they have given the criteria for the appointment of the cost auditor, and if you are eligible for that, then the compulsory the cost audit requirement is applicable.
Madam, one small clarification I want. You said that in the case of independent directors, if the company is making a loss, they are not entitled to get any remuneration. They'll be getting only the sitting fee, is it not? So they'll not get any remuneration for that.
Yes.
I see.
Independent directors receive only the sitting fees or the commissions. That is commissions which is decided by the board of director, and commission which is on the basis of the net profit, like the 1% commission or the 2% commission.
But
Or
this
the
is a loss. This is a loss-making company. In that case, there is no question of commission.
there is no such commissions, but they can take the sitting fees like 5,000, 10,000. Different companies have their different sitting fees.
No remuneration as such.
No, they cannot take the remuneration.
Okay.
Madam, another question came in the Q&A. Whether cryptocurrency is investment or current asset?
Okay, cryptocurrency, as I discussed with you, that is in the P&L portion. So that is profit and loss account. There is some changes in the schedule 3 in case of this particular buying or selling this cryptocurrency. So just we have to mention is the investment portions.
So cryptocurrency is a legal tender instrument in India.
Sorry, sir. Pardon.
This cryptocurrency is a legalized form of currency in India.
Sir, it's a banned nowadays. If I'm not wrong, this cryptocurrencies, we cannot buy and sell this cryptocurrency because recently they have banned this particular cryptocurrencies. But if any company who have the buy and sell of this particular this kind of virtual currencies and anything else is there, and any profit which is arises in this particular currencies, then we have to compulsory mention in this particular schedule 3.
No, then how it comes as a current assets or fixed assets? How
Sorry,
can
sir,
we
pardon.
include that as a current asset or a fixed asset? Since it is a bank document,
Yes.
can we consider it as a current asset document or a fixed asset document?
Sir, I'm not getting the last one line.
No, you said that it is banned, isn't it?
Yes,
Cryptocurrency
yes,
is banned.
yes.
Then what's the need of asking the question whether it will be considered as a current asset or a fixed asset?
Yes, sir. Cryptocurrency is banned, but here they have asked the question that is, it's a currency is an investment or a current assets.
Oh.
So this my answer that is a cryptocurrency is like buying this type of the currency is a one kind of investment because day by day the amount or we can say it's increasing.
Ma'am, another question came up in the Q&A. That's unlisted public company mandatory to appoint independent director.
Okay, as per the provision of 149 of the Companies Act 2013, that is, every unlisted public companies are not required to appoint independent director. There are the certain classified, they have classified this paid up capital and the turnover amount. So if they have classified in this, every unlisted public companies are not required to appoint, but yes, if they have classified in these provisions like the paid up capital and the turnover, then they have to compulsory required to appoint this independent director in this particular companies, and will give this idea about this what are the turnover and this paid up capital.
Another question came up is that explain about final statement of government companies.
Okay, sir. Explain about
Final statements.
Financial. Not get it, sir.
Maybe financial statements.
Final. Sir, I'm not getting the question actually.
It may be financial statements.
Financial statements of government companies. Which is covered under the CARO or Schedule 3 because I am not clarifying your question.
Question is not clear. No.
Sir, there are few questions in the chat as well. Ma'am, one comment has come is that one. The remuneration provisions are not applicable to private limited companies, right? That's what is. Whether it is applicable or not to private limited companies, that's what it is asked.
The remuneration provisions are 197, 188. Yes, sir, it's not applicable to private companies. One more clarification regarding this appointment of independent director, that as I talked with you earlier, that is at least 2 directors must be required, independent director, to all the public companies, not unlisted company. All the public companies who have the paid up capital of 10 crores or more, or the turnover 100 crores or more, or in case of they have the outstanding of 50 crores or more, that company are required to appoint at least 2 independent director in the in this particular companies. So I hope Vidya has clarified that particular doubt.
Ma'am, another one comment which has come, cryptocurrency is not banned in India as of now. That's what one In the chat, it was mentioned.
Just a minute, sir.
The last.
Chat or question answer, sir?
In chat, ma'am.
Yes. The cryptocurrency is not banned in India as of now. Right now, because as I have idea that the cryptocurrency is banned in India, that might be possible due to certain avoidance of these restrictions. Nowadays, it is not banned in India.
Ma'am, one more is that cryptocurrencies only recognized to taxing purpose if there is any gain due to the transaction.
Okay, cryptocurrency is only recognized for taxing purpose if there is any gain due to the transaction. Yes, it's recognized for the taxing purpose because here it's a gain. Because when at the time of the selling, the price is higher than at the time of the purchasing, then again, it's for the taxing purpose.
So now there is no questions.
Okay, explain question and Q&A session. Explain about financial statements of government companies.
Explain about the financial statements. How, sir, can I explain the financial statement? Because it's that means the auditor portion, that is how explain of this financial statement of government company. It's not like that. I cannot explain or about the financial statement because it's a different.
Okay, Arun sir, shall we move to felicitation?
Yes.
I invite CA Binoj Menon of Chairman Palakkad Chapter, Palakkad branch of ICIA to felicitate the webinar.
Thank you, sir. Thank you for giving an opportunity for closing remarks. Thank you, ma'am, CS Dr. Yashri Dikshit, for providing us a very valuable and informative session. In fact, it looks like a piece of cake with a lot of information. You have made in your presentation such a way that there are a lot of information available, but viewing and hearing that, it looks like a piece of cake. A few takeaways I'm sure that we all members will be taking with us is that we know about the important changes in amendment, like public company listing in foreign jurisdiction and masala bonds. We are all aware that last few years Kerala newspapers and media are talking masala bonds, so it will be striking us, yes. And filing of resolutions requirement MGT-14, limited of auditors, financial statements, and more importantly, you have clearly mentioned and in detail about the CSR set off and carry forward. And if it is less than 50 lakhs, no CSR committee. And the key thing, like which we all will be liking, that punishment, the change of the punishment to penalty, and lesser penalties for OPC and small companies, and maximum penalty. Many and the good, in fact, like section 92. If we comply with no penalty, and there are discussed about the education government, decriminalization, and these are and many amendments. One first April, and another alarming is that all the STP that 80 years. That's huge. Maybe that it's really alarming that they can take which we have to comply with. Other no resubmission, no alarm, no other choice. I believe we have to. And Schedule 3 amendments, ma'am, in detail around documents, notes on share capital and shareholding, like using of short-term borrowing, other non-current assets, notes on trade pay, loans, and more importantly, disclosures on utilization of borrowings. I am not sure that how it can be done, but yes, we have to get whether the law has been appropriately. That's our duty. The things has been from the mind as well, and ratio and disclosure of, and as we now discussing about the, yes, it's not, but I'm not sure whether it's legally buy and sell, but it came a note, and it's in PN. Lastly, we have this CARO, the reporting that physical verification audit system, statutory audit, and related party, and many be taken care. It's really original job, but we are can do it, and but change of the of the again. Thank you for it, and with also thank committee members for giving us an opportunity, giving me. Thank you, Aryan.
Yeah.
In fact, sir, voice was cutting in between. It's, anyway, we are a wonderful, respected members and dignitaries, and the speaker, Yashri Dikshit ma'am. We had a very wonderful, delighted session. This wonderful faculty, and a lot of the Sir Vinoj Menon sir told that it's a kind of cake we all had in the several recent amendments, changes on Schedule 3 and CARO and Companies Act. We had wonderful sessions, sir. This is the second session in series. We 4 chapters, we 4 professional bodies joined together to conduct in Thrissur. Such an overwhelming response we got. We have got at a time around 108, 110 participants logged in. We thank you, ma'am, for accepting our request to participate in this session. Such a contemporary subject, which is very much essential for smooth and erudite functioning of the members, professionals, both in practice and the profession employment. We thank all members of the Institute of Company Secretaries of India, Institute of Chartered Accountants of India, Institute of Cost and Work Accounts of India, and the Thrissur Management Association, and the respective members and the respective chairman for all their support and commitment. Madam, as a token of gratitude, we present you Shahid Ki Beti certificate, which will be, you will be aware that it's provided to support the girl child of martyrs who did supreme sacrifice for the nation. We will courier you the Shahid Ki Beti certificate now. And along with that, we will, as a small token of love and affection from our part, we will send you a memento to your address, ma'am. Thank you for accepting our request and participating in this session. Madam, we will continue to seek your support in future programs also. Once the things will be opened up, then lockdown will be removed. Thank you, ma'am. Thank you all members for participating in this session. Thank you all the professional bodies, chairman of the professional bodies. Thank you all. Thank you once again for the support and care.
Thank you.
Thank you, ma'am. Thanks.
Thank you so much, sir, for giving this wonderful opportunity. I hope everybody has enjoyed this session, and the first time all the institute are at one place, and I'm delivering the session at all the institute at a one place.
Thank you, ma'am.
We love hearing you. Thank you. It was nice.
Yeah. Thank you so much.